Hello friends, we are heading for the final few phases of general election. The battle is on fire, the battle is really on fire. There are charges and counter charges by the ruling NDA, the INDA alliance, but we do not know exactly what is going to happen. There are different analyses provided by different social media platforms, political experts, but we do not have any option. We'll have to wait for the 4th day of June till the Election Commission of India announces the results on their official website. Meanwhile, a few weeks before, the International Congress has came forward with their election manifesto, and the BJP has responded, obviously. One of the flashpoint in the election manifesto was taken forward by Mr. Rahul Gandhi, and he says wealth redistribution would be a promise. Okay, wealth redistribution would be a promise. So this is one of the headline news you may see in the social media. Rahul Gandhi stirs the pole port yet again, advocates wealth distribution. Very good. Now, what was the take on this issue by our Prime Minister, P.M Modi? P.M Modi reiterates jib on wealth redistribution, claims Congress wants to share it among their special people. Special people. Yes, my dear friends, he was actually referring to a particular community. We'll get into the details very soon. Okay. Now, later, there was another pitch by the economic advisor of to the Congress family, Mr. Sam Pitroda, and he is one of the person who claims the contribution in the telecom revolution in the field, in the telecom revolution field of India. Now, Sam Pitroda says Congress redistribution of wealth in interest of people, advocates for inheritance tax in India. Inheritance tax in India. We will try to understand what exactly is inheritance tax, but Mr. Modi was not ready to pay off. He says, PM Modi zindagi ke saath hi dig at Congress over Sam Pitroda's inheritance tax remarks. Kharge also responds. Mr. Modi says that the Congress is not ready to leave you even after your death. Understand, the level of charges which Mr. Modi has put forward is in fact a scathing attack. He says that the Congress will not leave you even after your death. That is what Mr. Modi says in this particular election campaign meeting. Now, before going into the political aspects, we would try to understand about the constitutional provisions about the wealth redistribution, whether it is constitutional or whether it is unconstitutional. What were the interpretations of the judiciary in this particular aspect, as well as we will try to understand what were the parliamentary inventions and what are the constitutional provisions which provide for the redistribution of wealth. Whether there is a requirement of the redistribution of wealth and on what basis Mr. Rahul Gandhi puts forward or the International Congress puts forward the idea of wealth redistribution. So in this particular session, as part of the Pulse of the Present series presented by IAS Hub, we will delve into the constitutional provisions in relation to the wealth redistribution. Okay, so as part of your mains exam, okay, so the topic for today would be part of GS paper 2 for your mains exam. So GS paper 2 provides for the governance, constitution, polity. So the wealth redistribution can be connected to this area. Okay, governance, constitution, polity, and under this you have the amendments, significant provisions, the government policies and interventions for the development in various sectors and issues arising out of their design and implementation. So this is going to be the topic for you today. Okay, so that is what you need to understand as a preface to this particular session. So about the redistribution of wealth through the Constitution of India. About the redistribution of wealth through the Constitution of India. Let's get into that. Now, when you talk about the constitutional provision, okay, the constitutional provision, just have the idea. This is the identity card of the Indian Constitution, isn't it? Mr. Nani Palkiwala said that the preamble of the Indian Constitution is the identity card of the Indian Constitution. It is practically not possible for each and every person to go through the entire Constitution of India to understand what is India. So instead, what that person can do is just read the preamble of the Indian Constitution. The preamble of the Indian Constitution provides for the source of power. You know that we, the people of India, the great people of India, is the source of power. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic. Sovereign, socialist. Sir, socialist. Absolutely. Yes. Socialist means taking the resources, equally distributing to all the people. This is what is the idea of socialism, my dear friends. So the preamble of the Indian Constitution provides a nature. Okay, it says that the nature of the Indian Constitution is socialist. Okay, is socialist. Sir, but socialist, the term was not actually part of the preamble of the Indian Constitution. It was later added by the 42nd Constitutional Amendment Act by Madam Indira Gandhi. Can it be claimed as a historical blunder committed by Dr. B.R. Ambedkar? No, my dear friends, you can see one particular important thing here. Understand, we, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic and republic, and to secure to its citizens justice, liberty, equality of status and of opportunity. Sir, equality of status and of opportunity. Sir, this is what is socialism. So this particular phrase was already in the Constitution. Absolutely, you are right that Dr. Ambedkar has not used explicitly the term socialism in the preamble of the Indian Constitution, but he was very clear, my dear friends, that it was equality of status and of opportunity. What is this? This is what is the Indian brand of socialism. If he would have been using socialist, the term in the original preamble of the Indian Constitution, then that would have made a perspective among the world that India is also the original socialist country. No, sir, we have a different version of socialism. And what is our version of socialism? Our version of socialism is mixed economy. What is our version of socialism? Our version of socialism is equality of status and of opportunity. So the preamble of the Indian Constitution clearly mentions that the economic justice, okay, the economic justice as well as the equality of status and of opportunities are the dream of constitutional forefathers. What is this? The objective of Indian polity. The objective of Indian polity, or you may say that it is the dream of constitutional forefathers. Wonderful. So start from the preamble of the Indian Constitution. The preamble of the Indian Constitution speaks about socialism, my dear friends. It speaks about equality of status and of opportunity. It speaks about the justice, which is social, economic and political. Economic justice, that is, have the resources equally, have the facilities equally among the people. So that is what the preamble provides for. If the UPSC asks you to provide the constitutional provisions, remember that you start with the preamble of the Indian Constitution in relation to the redistribution of wealth. So is this unconstitutional? No, my dear friends, there is nothing unconstitutional when it comes to the redistribution of wealth. It is constitutional. Why? Because our objective is economic justice. Our objective is equality of opportunity as well as that of status. Very good. Now, coming to the next constitutional provision. So when you go forward in the Constitution of India, you would see that there is part 3 of the Indian Constitution, isn't it? That is fundamental rights. Very good. Fundamental rights. Part 3 of the Indian Constitution, which speaks about the fundamental rights. So as per the original Constitution, my dear friends, try to understand, right to property was a fundamental right. Okay, right to property was fundamental right, and it was provided in 2 articles, that is under the right to freedom as well as under article number 31. Okay, so right to freedom says about or said about right to acquire, hold and dispose property. What does this mean? Sir, under article number 19(1)(f), as per the original constitution, there was a freedom for, you may say, the citizens of India to purchase land, to maintain that land, as well as to sell that land. So there was a right to property, which was a fundamental right. Now, Article 31 was providing for no person. So it was even extendable to, or it was extending to non-citizens also. It says that no person shall be deprived of his or her property except by authority of law. What does this mean? Sir, the government can take away the property providing adequate compensation, as well as it should be for the public purpose. Say, for example, for the construction of roads, construction of dams, for the benefit of the well-being of the people, for the benefit of the society, the property can be taken away by the government, providing adequate compensation. Now, what was the issue? The compensation was a headache for the government of India always, because the government was not having enough resources to provide for the compensation. Now, there was frequently conflict between the judiciary as well as the legislature. In between the judiciary and legislature, there was conflict. What was the reason? See, the government of India will come forward with a law taking away the property from the people to implement the socialistic principles and distribute to the common people. Now, the person who is affecting with this problem, he will move to the Supreme Court of India. He will say that, my lord, my right to property is being violated. My article number 14 is being violated. Even my article number 19 is being violated. Article number 14 speaks about the equality before law and equal protection of law. He says that, sir, my lord, the government is taking my property, but not my neighbor's property. That means my right to equality is getting violated. Even my article number 19(1)(f) is going to be violated. Article number 19 itself provides for the right to profession. Even that also is getting violated. So that is what the Supreme Court will always consider, isn't it? The Supreme Court is the guarantor of the fundamental right, isn't it? Guarantor of the fundamental right. And the Supreme Court will have to provide a kind of remedy for those people who comes to the Supreme Court of India saying that their fundamental rights were violated. So the Supreme Court will provide certain interventions, the Supreme Court will provide certain remedies, and that actually proved a headache for the legislature. So that is the reason why the parliament has came forward with different constitutional amendments, like the 42nd, first constitutional amendment, 4th, 25th, etc., etc. And they have introduced certain articles like article number 31A, 31B, and 31C. We will try to understand what exactly is the scenario. So now try to understand that there was two provisions regarding the right to property in the constitution. It was provided in fundamental rights, that is part 3 of the Indian Constitution. Article number 19(1)(f) was speaking about the right to acquire, hold and dispose property. Article number 31 was speaking about no person shall be deprived of his or her property except by the authority of law. Now, coming to the next part, we will try to understand for the implementation of socialistic principles. So we are speaking about the conflict between the directive principle of state policy and the fundamental right, basically. Now try to understand this. Sir, for the implementation of the directive principle of state policy, that is Article 38 and Article 39. Okay. So what is directive principle of state policy? So, directive principle of state policy means those instructions given by the Constitution of India to the government or to the state to establish a welfare state, isn't it? Welfare state. That is a state with justice as paramount. This is what is the idea of a welfare state, a non-profit oriented state, a social well-being state. That was the idea of a welfare state. Now, the directive principle of state policy, as I have already told you, those were instructions provided by the Constitution to the state, to the Parliament of India, to the Government of India, to take into consideration certain principles for the establishment of a welfare state, but those instructions or advices were non-justiciable. That means even if the government does not implement it, it is not something which can be made enforceable through the court. And that was the difference between fundamental rights and DPSP. So DPSP, is it your right? Absolutely you are right. But can you enforce it through the court? No. Sir, then how it becomes right? You can enforce it through the elections, the public opinion, my dear friends. After 5 years, when the political representatives, the political leaders come to you requesting for the vote, you can question them. This is what is democracy, the beauty of democracy, my dear friends. So for the implementation of these directive principle of state policy, the Parliament has come forward with the first Constitutional Amendment Act of 1951 and has inserted article number 31A, 31B, as well as even the 9th schedule of the Indian Constitution. Are you getting the idea? Now, what was article number 38 providing for? 38 was providing the instruction to the state to minimize inequality. Okay, to minimize inequality means take the property from the rich, distribute it to the poor. That may be one of the way, isn't it? Now, article number 39, again a DPSP, says that equitable distribution of wealth and property. The government, the state, you always consider framing laws for the equitable distribution of wealth and property. So that was provided by article number 39. So to give effect to these two directive principles, one, to minimize inequality, second one, equitable distribution of wealth and property, you will have to do some changes in the constitution, or you have to amend the constitution, and that is what Mr. Nehru has done through the first Constitutional Amendment Act of 1951. He has inserted, the Parliament has inserted article number 31A, 31B as exceptions to the fundamental right. Understand, these are some exceptions to the fundamental right. Exceptions to the fundamental right. What does this mean? Sir, even though your right to property is violated by the state, that should not be actually considered as violation of the fundamental right. This is what is the idea. Your right to property may be violated, but that would not be considered as violation of fundamental right. And that is what article number 31A speaks about. Article number 31A says that, try to understand this, article number 31A says that laws made for acquisition of estates. In fact, you have 5 categories. One of the category is laws made for the acquisition of estates. So laws made for the acquisition of estates, etc., shall not be void on the ground that it is in contravention to article 14 and 19. Wonderful, great. See this, even if the law that is made to acquire the property, that is acquire the estate, even if that violates the fundamental right of article number 14 and 19, it shall not be considered void. This is what is the language of article number 31A. That is, you may violate article number 14 and 19. That may not be considered violation of fundamental rights if the law is put forward for the acquisition of estates. Is it clear? Now, what does article number 31B says? Article number 31B says, or article number 31B, in fact, saves certain acts and regulations. Okay, this is like a protection or immunity, you may say. Okay, save certain acts and regulations placed in the 9th schedule from being challenged and invalidated on the ground of contravention of any fundamental right. My goodness. In other words, what does article number 31B says? That there may be certain acts and regulations like the acquisition of estates. It may violate any fundamental right that may not be challenged, or that shall not be challenged or invalidated on the ground of violation of fundamental right. This is what is the language of article number 31B. So article number 31B was little bit more expanding of article number 31A, or you may say that article number 31B was an expansion of territory of article number 31A. Understand? The basic intention is to give effect to these two directive principles of state policy. While you are giving effect to these socialistic principles, that may result in the violation of the fundamental right to property, but that should not be considered as violation of right to property. This is what article number 31A and 31B puts forward. And even the 9th schedule was also put forward. The 9th schedule is just a box. You may consider 9th schedule as a box, and the laws that are put in the 9th schedule, those laws cannot be challenged by the court. That was put forward by the first Constitutional Amendment Act of 1951. But in the famous I.R. Coelho case, you can refer this also, as we are going for the judicial interventions also. In the I.R. Coelho case, the Supreme Court was very clear. My dear government, my dear Parliament of India, we are really sorry. There is no blanket immunity from judicial review. Even if you place an act regulation in the 9th schedule of the Indian Constitution to claim exceptions or immunity from judicial review, we are really sorry. We will check it. Why? Because judicial review is one of the basic structure of the Indian Constitution. So what this particular case judgment says is that from 24th April of 1973, understand this particular date, 24th April of 1973, even if you have put any laws in the 9th schedule of the Indian Constitution, we will check it. Sir, nothing is beyond judicial review, sir. Nothing is beyond judicial review. The judiciary can check everything and everything, each and everything. Now, what is so special about this particular date of 24th April of 1973? Sir, this particular date is one of the historic date when you talk about the history of Indian judiciary. A landmark judgment, 13-judge bench. I mean, in the Keshavananda Bharati case, they have said that Parliament, you may be so powerful, the leader of the Parliament may have that kind of vast majority, but you are not supposed to touch the basic structure of the Indian Constitution. The famous judgment provided by the Keshavananda Bharati case judgment. Okay, the famous observation provided by the Keshavananda Bharati case judgment. Fine. So now the status quo is that even though you put any of the laws or acts or regulations in the 9th schedule, that would be checked by the judiciary. Why? Because it is already over. This particular date has already been got. So this is what you need to understand regarding article number 31A and 31B. Finally, there is one more constitutional provision, that is article number 31C. Article number 31C was inserted by the 25th Constitutional Amendment Act of 1971. Now, what does article number 31C says? No law that seeks to implement the DPSP specified in article number 39B or C shall be void on the ground of contravention of fundamental rights conferred by article number 14 and 19. What does this mean, sir? No law that seeks to implement the DPSP specified in article number 39B and C. Okay, 39B or C. 39B or C shall be void on the ground of contravention of fundamental rights conferred by article number 14 and 19. In simple terms, try to understand, my dear friends. Article number 14 and 19 is not superior to article number 39B and C. This is what is the idea. Are you getting this? So 39B and C, even if it is a directive principle of state policy, it has got a superior nature over the fundamental rights of 1419. In other words, sir, there are laws which you can frame on the basis of the directive principle of state policy under article number 39B and C. They may be socialistic principles, and these socialistic principles can violate or may violate article number 14 and 19. Why? Because article number 14 and 19 is inferior in comparison to these two directive principle of state policy. No problem. Just wait. I'll make it more simple now. Just understand this. Article number 31C may be understood in simple terms. In simple terms, 39B provides for equitable distribution of resources. Okay, as I have already told you, equitable distribution of resources. This is what is the idea of socialism, isn't it? Equally distributing the resources among the poor. 39C says about no concentration of wealth. What is this? No concentration of wealth. Fine. So 39B or 39C is superior to Article 14 and 19. So any law that is framed by the Parliament of India for giving effect to the directive principle of state policy of Article number 39B and 39C, even if on the violation of Article number 14 and 19, does not become invalid. Getting this? But it is under the judicial review. That means the 25th Constitutional Amendment Act provided for one more provision also, that such laws may be immune from judicial review, but the Supreme Court in the Keshavananda Bharati case said that judicial review is something which cannot be taken away. We will definitely check it, isn't it? We will definitely check it. So it is under the judicial review. Now again, the Supreme Court or the judiciary can interfere as well as, as long as the right to property is fundamental right, the Supreme Court can interfere in this. So that is the reason, finally, by the 44th Constitutional Amendment Act of 1978, Mr. Morarji Desai has decided that we will omit right to property from the list of fundamental right, and he has inserted in part 12 of the Indian Constitution article number 300A, which speaks about the right to property. So what is the present status, the status quo of right to property, my dear friends? Right to property is now a legal right. Right to property is now a constitutional right. So right to property is legal right. Right to property is a constitutional right. Is it a fundamental right? No, my dear friends. Does it come under the basic structure of the Indian Constitution? Absolutely no. Absolutely no. Sir, what do you mean by right to property as a legal right? We will try to understand that also. Okay, you may have a question from this area for the prelims. What is the interpretation of right to property as a legal right? Try to understand this. Sir, legal right. Yes, legal right means you may amend the right to property by an ordinary legislative process. That is, you may amend the right to property with a simple majority in the parliament, my dear friends. Simple majority in the parliament, which is part of the flexible feature of the Indian Constitution. Okay, flexible feature of the Indian Constitution. So it is not a tough process that you can amend the right to property as an ordinary legislative process. Now, coming back, the right to property can be taken away by a legislative action. In other words, right to property cannot be taken away by an executive action, but it can be taken away by the parliament, the state legislature. Are you getting this? So protection against the executive action only. There is no protection against the legislative action. Getting it? The second interpretation. The third interpretation. Sir, my right to property is violated. Now, can I go to the Supreme Court of India? No, my dear friends, you may not directly approach the Supreme Court of India. Why? Because it is no more a fundamental right. It is only a legal right. Sir, then where can I approach? You may approach the High Court under article number 226, and of course by way of appeal you can move to the Supreme Court of India, but there is no original jurisdiction for the Supreme Court in matters, in fact in matters that is out of the violation of the fundamental right. In legal rights there is no original jurisdiction for the Supreme Court of India. Fine. Or in matters of violation of legal right, there is no original jurisdiction for the Supreme Court of India. Fine. The next one, there is no guaranteed right to compensation. Sir, you have no guaranteed right to compensation. Your property can be taken away. The compensation was the headache. Now there is no guaranteed right to compensation. Sir, it is for the social well-being. The state is taking into account, the state is accounting your property and understanding that you have the property in surplus. Now there are people who does not have property, who does not have land, who does not have a home to stay, who does not have a shelter. So right to shelter is also a part of right to life and personal liberty said by the Supreme Court of India, isn't it? So can you say that your society is in fact hailing the idea of justice if they do not provide the shelter for some and they provide AC, air conditioned apartments, flats, villas for others? No, sir, the justice is denied. One of the principle or one of the objective, one of the dream of the constitutional forefathers was about the social justice, about the economic justice, isn't it? So there is no guaranteed right to compensation, but there are two exceptions to this particular provision. Two cases the compensation is compulsory. Okay, so there are two cases where the compensation may be compulsory. Number one, if the state is taking away the property of a minority educational institution. Okay, if the state is taking away the property of minority educational institution, the compensation is compulsory. Okay, the compensation is compulsory because the minority educational institutions, the right to establish, administer, manage the minority educational institution is their fundamental right. So the compensation is compulsory, as well as if the property is within the statutory ceiling limit. What do you mean by statutory ceiling limit? In certain states, there is a statutory ceiling limit set by the state legislature that a family can own only a particular amount of land. And if the family is owning above this, the family is possessing above this, that particular land can be taken away by the government without compensation if it is within the statutory ceiling limit. Okay, if it is within the statutory ceiling limit, say for example 10 acres, if this is fixed as the statutory ceiling limit for a family, just understand for an example. Now if the family is having only 10 acres of land and the government wants this piece of land for the construction of road, the government will have to give the compensation. If the family say has 100 acres of land, sir, the ceiling limit is 10 acres, so the 90 acres of land here is surplus. Without compensation, the government can take away their property. So these two are exceptions provided. One is in relation to the property of minority educational institution. The second one was in relation to the property which comes within the statutory ceiling limit. So these two areas or these two cases, the compensation is compulsory. Clear? Fine. Now, what were the steps taken by the government from 1950 for the implementation of the directive principle of state policy, that is the socialistic principles? Okay, so we will trace the events from 1951 to 1991. Okay, 1951 to 1991, we will understand the situations. So of course you know about the land reforms for the property redistribution. Sir, land reforms, taking away the property from the zemindars, the rich landlords, distributing, trying to distribute it for the poor farmers, the landless farmers, for the cultivation, for the shelter, all those kind of things. So what did the government do? The government has come forward with the Zemindari Abolition Act. The government has come forward with the Tenancy Act, the Land Ceiling Act of 1961, as I have already told you, the Land Ceiling Act. Fine. The government has even considered financial inclusion. Okay, financial inclusion. Nationalization of banks, nationalization of insurance sector. Why nationalization of banks for financial inclusion? Sir, there were so many private banks, they were considering only giving loans, helping only the corporates, or in fact the rich landlords, the zemindars. They were not having a look on to the poor landless farmers or those kind of underprivileged sections. So that is the reason why there was nationalization of banks. So you know the year 1969 as well as in 1980 there was nationalization of banks, as well as insurance sector nationalization has done even before. I think if my memory is right, it was in 1950s itself you had the nationalization of insurance sector. Fine. Now further, to reduce the income inequality, there was high rate of direct taxes, estate duty, and even the inheritance tax also. What do you mean by inheritance tax? Say for example your father or your grandfather, okay, he or she purchases say for example a piece of land near the national highway, with his or her effort. You do not have any effort in that. Now, after the death of the grandfather or the grandparents or the parents, that property will be inherited to you, isn't it? That property will be given to you, and that property will be taken by you, and you will have to pay a fixed amount to the government as an inheritance tax. Some of the states of US even implements inheritance tax, and this was Mr. Sam Pitroda was advocating for. He was batting for inheritance tax. He was not speaking about the wealth redistribution per se. He was speaking about the inheritance tax. Now, understand, now in India we does not have this inheritance tax. Fine. Yeah. So that is what is inheritance tax. Now, what is the problem? What are the problems in relation to this? So there are certain problems. Sir, if that heavy tax burden on even the corporates are there, they will try to hide it from, isn't it? They will try to hide it from the government officials, from the government offices. So there will be concealment of income due to high taxes, and it can lead to the black money, isn't it? The administrative cost to find this concealment would be another disaster, isn't it? The government would be able to get the money or use the money only for the administrative cost, or only to meet the administrative cost to find out the concealed money or concealed resources. So these are some of the problems, and that is the reason why in 1991 we have gone through, or we have decided that we will go for a liberalization, privatization and globalization. So what has happened there? Reduction in direct taxes, estate duty as well as wealth tax has abolished. Okay, or you may say that there was reduction in direct taxes, estate duty and wealth tax has got abolished. So try to understand, this statement is very, very important. Direct taxes were reduced and estate duty and wealth tax has got abolished. Very good, fine. Now, why redistribution? Isn't it? This is the most important question. Why redistribution? As per the World Inequality Report of 2022, in India, the richest 10% owns 77% of national wealth, my dear friends. 77% of national wealth is under the authority or control of richest 10%. Now, what about the poorest 60%? Only 4% of national wealth. Who has confirmed this? The World Inequality Report of 2022. So that is one of the reasons why Mr. Rahul Gandhi would have pitched the idea of wealth redistribution. Mr. Modi says that if the Congress is voted to power, the Congress gets the power, then they will loot the money of the people and they will distribute it for their favorite ones. And Mr. Modi was clearly indicating that the Congress party would try to favor or try the appeasement politics of favoring Muslim community in specific, and that is what is the danger here. Okay, fine. Now, what is the way forward? What can be done? Okay, what can be done? Number one, the conditional property rights. Okay, conditional property rights. That means the person should be allowed to use the property, allowed to own the property, but it should not be misused. Okay, it should not be misused. It should be in adherence to the environmental laws, all those kind of other contribution like the CSR. Everything needs to be met. The focus on social justice, that is housing and land for all. This should be given the prior consideration. Okay, focus should be on social justice, that is housing and land for all. So in fact, what you need to understand is that we should have a balanced approach. Okay, we should have a balanced approach. So this is in fact what you need to understand in relation to the topic, that is about the wealth redistribution through the constitutional provisions. I hope you have enjoyed the session. With a new topic we would see in the next session. Till then, it's goodbye.